So good morning, everybody, and welcome to this webinar. I am Barri Graham. I'm one of those 27,001, I'm happy to say 27,701 assessors. Hello to all those I've met previously in 2019. I hope that you are well. And to those I've yet to meet or lined up to meet soon, an equal Happy New Year. I hope that your first week back hasn't been too painful. Today I'm going to be examining the new 2771 privacy information standard, which is PIMS for short, PIMS. In 2018, both Data Protection Act and GDPR hit, terms which, if you're not familiar with, I'll briefly explain as we progress. They were implemented and they directly affect UK industry across all sectors where the collection or processing of private data is undertaken. The relative speed at which the rollout of legislation has been established has left a bit of a gap, and some organisations have been unable to adequately respond, and some well-publicised breaches have occurred. The development of the 27701 standard will hopefully address some of the concern surrounding this. As you've already received an email from the marketing team, I'm sure you'll be aware of the areas we aim to cover, but as a quick refresher, we'll be looking at a legislative overview, why PIMS and the standard has been developed, what compliance will mean to your business, including the benefits and potential pitfalls, and the implementation process to conclude this presentation. Additionally, you can also download for free previous 27701 webinars and the blogs which align to them, and they're available on the NQA website. Well worth exploring if you've not done so already. They're a PIMS introduction to what PIMS is, and more of a guide to PIMS as opposed to implementing PIMS against your existing ISMS. It will certainly give you a foundation to understand what we're going to explore today. I'm happy to answer any questions as you see fit as we go along. Just please type those into the questions box and I'll be able to pick those up. There'll be ample time once we finish to pick up any questions we haven't directly addressed during the presentation. So don't worry if we skip something and you want to pick that up later down the line. Additionally, I've left my email details on the conclusion slide. So if you do have to leave us at any stage during the webinar, there's a way to reach out to me, which I'm open to answer any questions you have. Okay. Finally, I'll remind you now that you receive a full copy of this recording of the presentation along with the slide deck once the webinar is complete. As this is a standard and the legislation it addresses is such a large and ultimately important consideration, I'll have to restrict or tighten the webinar to be a brief overview and initial implementation guide only. In the future, there'll be a second in the series, so to speak, of webinars which provide additional guidance to build upon what is learnt during this initial presentation. Now that we've introduced ourselves and explained what we're doing, let's get into this. If you can't hear me, I've just seen a question there. If you can't hear me, please indicate within the questions box and we'll try and get this fixed as we go through. Okay. As it says there, NQA is a large global client base and has been serving these for over 30 years now, issuing a large number of certificates globally. So you can rest assured, regardless of what standard you are looking into, that you are in good hands. We work with a variety of clients from single management systems to complex multi-site organizations with multiple management systems in place. NQA is able to tailor their approach to support each individual client and their circumstances and make a unique price promise. As briefly mentioned, here is an outline of what will be covered during this webinar. I'm talking to you today from the UK and for now at least the EU, so I will focus on the legislation pertinent to this area. However, there have been other data privacy developments globally, and though I cannot cover all of them in one go, I can certainly point you in the right direction if you need this via the medium of question or email response. Armed with the understanding of the legislative background, we'll move on to the development of the standard and why it has been rolled out. We'll then look at what compliance to the standard will mean and how the implementation of a personal privacy information management system to augment your existing information security management system will provide benefit. We'll begin with terminology which is used in 27701, which ordinarily you may not be have encountered or be overly familiar with. And then to conclude, we'll then examine the standard in detail and look at some of the implementation considerations. Just to remind everybody that the presentation and slide deck will be available to everybody once the webinar is complete. So if you've missed some bits due to technical issues or the slides move too fast for you to catch up with, then don't worry, we'll email you the slide deck on completion. So when examining the 27701 standard and the language used within the legislation it addresses, there are some notable differences with the language used in ISMS and general security terminology. Some of the more pertinent and applicable examples are on screen. So whenever today we encounter PII, that's personally or identifiable information, PIMS is privacy or personal information management system, dependent upon the source of the information, it's written in different ways. A PII controller is the entity who determines the purpose and the means of data processing within an organization. The PII processor is similarly responsible for the processing of data. The PII principal is the person to whom the PII relates. So that's the individual who originated that information which is in use. And some of the common ones we're going to encounter today are ICO, Information Commissioner's Office. That's for UK, they have a UK remit only, and pseudonymization, excuse me, and this is a technique that replaces or removes information in a data set that identifies an individual specifically. And this may involve replacing of names or other identifiers with which are easily attributed to an individual, for example, a reference number. So it's switching a name for a number, which is only traceable by the person who changed that data. We established this early as the remainder of the slides, this language is in use. So again, if you've got the slide deck further down the line, you can sort of flick backwards and forwards to make sure that you're up to speed with the terminology. So PIMS in more detail then on personal details and what is personal data. So the privacy information management system are systems which help give individuals more control over personal data. We've all been subject to, do you accept cookies on this website and things of that nature? And this is what this is. It's more control for the individual. The PIMS allow individuals to manage their PII in secure, local or online and hard copy environments, and to have the choice over where it is shared and who it is shared with. The basis of a functional PIMS is balance between the protection and privacy, and there's a difference which I've brought to light on screen there between the main difference between what data protection and data privacy is. Today we'll mainly be looking at privacy and the means through which it empowers individuals to make decisions about who can process their data and for what purpose it is processed. So what constitutes personal data? It is information that relates to an identified or identifiable individual. And some of that is displayed on the display on the screen. What identifies an individual, it could be as simple as a name or a number, or could include other technical identifiers such as an IP address or cookie, or other factors on personal information, email address, phone number, picture, anything really, anything that identifies an individual. Even if an individual is identified or identifiable directly or indirectly from the data which is being processed, it is not personal data unless it relates to the individual. When considering whether information relates to an individual, you need to take into account a wide range of factors, including the content of the information, the purpose or purposes for which you are processing it, and the likely impact or effect of that processing on the individual. It is possible that the same information is personal data for one controller's purposes, but is not personal data for the purposes of another controller. Information which has had identifiers removed or replaced in order to pseudonymize the data is in the eyes of GDPR. So we've established what a PIMS is and what constitutes personal data, and we'll have a look at the legislation now which protects the latter. And depending upon when you listen to this webinar, there may be a change in background, but at the moment, Britain is still part of the EU with Brexit negotiations ongoing. And we'll have a look at Brexit in more detail next slide. So the legislative considerations for organisations operating in the UK today on the 10th of January are shown on screen. There are some differences between DPA and the GDPR, including age of consent, for example, and DPA doesn't offer as many freedoms for processing of criminal information, for example. But it's important if you're operating in the UK or from outside of the UK into the UK that you have an understanding of the legislative requirements for both DPA and GDPR. So under Section 3 of the European Union Withdrawal Act 2018, the GDPR will be incorporated directly into domestic law immediately after the UK exits the European Union. In terms of the effect on EU legislation, a no-deal Brexit may realise a complex and potentially very costly outcome for businesses which are reliant on cross-border data transfers with the EU. And this is all dependent upon the nature of the way in which the UK withdraws. When it's outside of the EU, the UK will be given third country status. Countries which are in this category have to show that their data protection laws are robust enough if they are to secure an adequacy agreement. An adequacy decision permits cross-border data transfer outside of the EU, which the UK may well be, or onward transfer from or to a party outside the EU without further authorization from a national supervisory authority. And that's Article 45(1) of GDPR. Now, the UK government's position is clear, and it has been made clear recently in that it will seek this adequacy agreement with the EU. However, the process for this can only kickstart once the UK has actually left the EU. Therefore, at the time of this webinar, there is a period of uncertainty in place. And until clarification is given about the nature of the UK exit, it's going to remain a uncertain area. So essentially, going back to the other slide, the DPA and the GDPR will still apply post-Brexit, but the nature of how information transfer occurs, dependent upon the adequacy decision, is still in the balance. So there is one of the legislations against which the standard has been generated. As mentioned, the focus for this presentation is going to be on GDPR and DPA 18. There are other global legislative considerations which are in effect and should be considered if you operate or intend to transfer data to those other areas. China and the US, for example, have a patchwork of legislative considerations which address PII, and in the case of the latter, this can be layered across state-specific requirements, such as the recent California Act, and federal considerations which have further additional enhancements required on any state legislation. So it's a complex environment out there with overlapping requirements depending upon the legislation you are working under. So we'll look at the development of the standard now and some of the benefits of implementation, which hopefully untangles that knot. So the ISO 27001 standard formally specifies an information security management system. And this is a suite of activities concerning the management of information risks, called information security risks in that standard. And the ISMS is an overarching management framework through which an organization can identify, analyze, and address their risks. The management system ensures that the security arrangements are fine-tuned to keep pace with the changes to security threats, vulnerabilities and business impacts, and an important aspect in such a dynamic field and a key advantage of 27001's flexible risk-driven approach. The new standard is designed to be an enhancement, a technical enhancement or bolt on, if you would, to an existing ISMS. It's not a standalone entity. So if you're in a position now with no existing 27001 certificate in place, then you will need to achieve that before applying for and trying to implement 27701. Most of the rest of this presentation assumes that you either have or understand a functional information security management system on which to add the requirements of 27701. Regardless of the maturity of an existing ISMS, which is aligned to 27001, there is no guarantee at present that data protection needs are adequately considered, especially since the introduction of the legislation which we've looked at in previous slides. Existing certificates for 27001 does ensure that organizations demonstrate that information security is in place within an organization. However, data protection requires that an organization goes a step further. Let's take information protection. At present, an organization with a 27001 certificate has information protected, and it's obtained this through routine activity and building in a management system to their organization. Data privacy requires that this goes further still, and that the rights of data subjects, PII principles, are considered. Clearly, 27001 alone does not allow for this. And so here we are, the development of an ISO PIMS. ISO are recognized internationally as the authority on management systems and best practice. The publication of an ISO certificate carry a great deal of weight, and certification to their management systems through recognized certification schemes are an extremely effective way of both meeting compliance demands and proving your compliance to customers, business partners, and regulators. Well, there are some publications and standards that discuss data protection, specifically looking at British Standard 10012. They're not international and primarily focused on data protection requirements and good practice in specific jurisdictions. So, for example, the BS looks at UK law and draws solely on GDPR and DPA 18, to give one example, and doesn't consider other international needs and isn't perhaps as widely recognized internationally. Crucially, this means that ISO 27701 a range of data protection and privacy legislation to give peace of mind to organizations with pan-regional business concerns. 27701 defines the extra requirements for an ISMS to cover privacy and the processing of PII. These are supported by additional controls that relate specifically to a data protection and privacy. As a new whole, this creates what the standard calls a privacy information management system, or PIMS. So what are the pitfalls? As previously indicated, when legislation was rolled out, 2018, there's been no guidance since on how to effectively implement processes within an organization's existing structure to adhere to GDPR. The PIMS for 27701 is a private extension to a well-established ISMS standard. So some of the figures on the screen there show that since the rollout of GDPR, there's been just a large number of incidents, including some that are live. We're thinking Travelex, some that are recent, such as Google or BA. Instances of breaches have been well publicized. They've affected all kinds of organizations and individuals, even where the primary base of operations has not been in the EU. A recent report from Capgemini outlines that up to 70% of all organizations believe that they may not be currently compliant to GDPR requirements, and therefore it makes sense that a standard to cover these bases is implemented. The information shown on screen acts as, if you like, the stick. The implications of data privacy breach can be severe. Without specifying any individual organization, although we did, who felt the full power of the legislation, it is easy to search. And when we think of search, we look at Google. And yes, they themselves have fallen foul of GDPR through their lack of consent on advertising. And this was brought to court in France and set them back on almost 50 million euros. But there are benefits. The benefits of information of ISMS are well documented, and here are some of the wider implications for an organization for the implementation of the technical extension in the form of PIMS. 27001 provides a framework from which an organization can identify risk and then address those risks. And 27701 is able to give greater clarity and assurance on the compliance of legislative and regulatory requirements due to the specific focus on subject areas. Information security risks identified in 27001 and 27701 provides the means through which an organization can communicate and consult upon risk. The output of this can significantly reduce compliance workloads by negating the need to support multiple certifications. Furthermore, it could increase trust between the organization and customers by providing a demonstrated compliance with data privacy law. It can generate evidence that DPOs, data protection officers, can provide to senior management and board members to show progress on privacy regulatory compliance. And it can increase the opportunity for business and commerce for cross-border data flows, which is increasingly prevalent. So this additional training needs, which can be identified and realized for information security and data privacy, and reduce costs by implementation strategies, which reduce the risk from potential data privacy breach. So there's clearly a network of benefits to implementing the technical bolt-on, the technical extension to 27001 to have the personal information management system running in tandem. So how do we implement it then? Hopefully, most of us will be familiar with the plan, do, check, act cycle, which is shown on screen. This incorporates the clause commonly associated with management systems. 27701 provides an additional layer to the existing PDCA cycle, and that's on screen now. The features shown will be brought to life during the next part of this presentation, including where and when does PIMS require additional considerations on top of what exists already. To fully implement the Privacy Information Management System, an organization must first have an ISMS as a foundation to attach the requirements. 3 areas of this technical extension must be addressed, and those are displayed on screen. Clauses 5 and 6 give direct extensions and requirements for enhancing ISO 27001 clauses and controls respectively. These are covered in detail in slides to follow. Likewise, Annex A and Annex B of 27701 throw up new requirements which you will not have encountered within your ISMS, which are PIMS specific controls for PII controllers and PII processors respectively. As they are controls which are aligned to the standard, this requires an organization to produce additional statement of applicability in a similar vein to that which was created for the ISMS controls. So hopefully all organizations with 27001 will currently have an SOA with 114 controls listed, and then indicate within there whether they have been implemented in their system or not, and then justifications for exclusions and inclusions. Similarly, for PIMS, an SOA is required for PII controllers and PII processors and should be raised with each control listed in a similar fashion. The exact construct of this is covered to the end of the presentation, so we will get there, don't worry. However, conceptually, the requirement is the same. Each control must be listed and then either justified as included or excluded, depending upon the nature of your business. For now, though, we'll move on to Clause 5 and the requirements of the new standard for existing ISMS clause extensions. This table on the screen now shows the ISMS clauses you should hopefully be familiar with, and certainly those with existing ISMS will certainly be familiar with, and how these are mapped across to the new 27701 subclauses and where additional considerations and requirements are needed. Where there are no PIMS specific requirement, there should be an extension to existing terms, and we'll show what that means next. It's just changing the word slightly to include data privacy. You can see here that the functional ISMS will require only a small additional piece of work in the context and planning areas to address the specific needs of PIMS, and we'll look at these in detail when it follows. I am aware, because the clause numbers do not directly correspond between the standards, there may be some initial confusion when you're looking through this table. For example, clause 4, 5, and 6, context leadership planning, are known as 5.2, 5.3, and 5.4 subclauses in 27701. It doesn't directly map across, which is unhelpful when you first get into grips with what the standard is. As mentioned numerous times, this table will be yours on conclusion of this presentation, so keep it handy when you're doing a review in the future. So let's examine clause 5.2 from ISO 27001 and how an extension to term looks. So I've highlighted in orange there where information security exists in 27001 and the requirement to include and privacy considerations as you work your way through. So clause 4 of 27001 is context of the organization. Note that, as we pre-warned, the clause number for 27701 differs slightly. This is 5.2 in the new standard, 27701. For 27701, an organization must consider additional things and enhance existing policies, and those are shown specifically on screen now. So just to handrail through the factors on the right. So organizations implementing the PIMS must now determine the role of the PII controller and/or PII processor within the organizational context. So where do these entities sit? They must include any interested parties which are associated with the management system which process PII data. Include PII processing in the scope of the ISMS. Now, this does not necessarily reflect a requirement to change the scope statement which you have on your certificate already. However, this activity must be considered for the organizational scope as a whole. And finally, for this section, a slight extension to the ISMS in terms of inclusion of PIMS. Similarly, the planning clause from ISO 27001 is 6, though the corresponding clause for 7701 is 5.4. The additional requirements are as stated, with the latter standard are on screen for review. In a similar way, it's an extension of term for 5.41 and application of confidentiality, integrity and availability risks processes to the scope of PIMS, and that's processing PII data. And then finally, when reviewing the controls determined in Annex A of 27001, the applicability of control objectives and controls should be considered in the context of risks to the processing of PII and to the PII principle. So how the additional requirements for the Annex A area of 27001 to map across 27701 is going to follow. Again, it's a lot to take in one go. And certainly, when I was reading this, it was a lot to take in. I appreciate that, but hopefully, as you work through it again and again, it will begin to make a little more sense and become clearer. So clause 6 of 27701 provides guidance on additional requirements for existing Annex A controls, which you have in your SOA for 27001. And on the table there, I've included the Annex A control as it exists now, the clause extension where it is required only for 27701. You'll note there are some gaps. Not every Annex A control from the ISMS requires an additional extension. This is brought out in the standard. The next few slides are just those areas of Annex A from 27001 which require a piece of additional work. I've tried to summarize in the additional requirements column and bring the more pertinent points forward. We don't have enough time or enough space on slides essentially to cover every single requirement or implementation guidance notes as detailed in the standard. I'll leave that to you to sort of do slow time. What I have done is try to bring out the sort of more pertinent points to get to the bottom line of the requirement. So for 511, which are policies for information security, organizations are now required to either develop a separate privacy policy or augment ISMS policy to produce a statement showing support and commitment to achieving compliance with PII legislation and regulation. And this includes contractual terms between an organization and its interested parties. And working our way down, 611, the requirement for 27701 is asking an organization to designate a point of contact for the customer or PII principal to reach. Further to that, an entity to establish and maintain a program to realize compliance with legislative requirements is required, and this is often in most organizations today a data protection officer. And data protection officers can be an organic entity from within an organization or an outsourced function. How that works is up to you. So mobile device policy 621, this is a fairly straightforward addition in ensuring that existing policies are augmented to make mobile devices and PII compromise holistic and addressed. So loss of information through mobile devices should definitely be included in policies. Information security awareness, education and training. I hope this is fairly self-explanatory. A lot of organizations I visit do have a GDPR training module as part of their annual mandatory requirement anyway. If not, the new standard requires this be addressed. So information classification, consideration of PII within the overall system is a key step in understanding what PII is being processed within an organization, where PII is likely to be stored, and what systems PII is in use. So the classification must include PII considerations now. Similarly, labeling of information. An organization should now ensure that people under its control are made aware of the definition of PII and how to recognize the information that they are using is PII. So management of removable media and disposal of media has additional requirements. And an organization now has to identify where removable media or removable devices have stored or do store PII and take steps accordingly. And secure disposal procedures which specifically address removal of PII are to be implemented in existing policy documentation. For physical media transfer, if physical media is used for information transfer, then a system now has to be established for recording incoming and outbound media which contains PII. And the record has mandatory fields to include the type, authorized sender and recipient, the date and time, and the number of the media in use. Where possible, encryption should be implemented to protect any information in transit, and any PII which leaves a premises physically should be subject to authorization procedure. So there's some mandatory activity to go on now around physical media transfer. Likewise, for user registration and deregistration, 921, the organization is now explicitly directed to not reissue users with any deactivated or expired user IDs for systems and services that process PII. So there's much more of a consideration about how old accounts are reallocated essentially. And there's some other, it's all contained within the standard, but there's some other guidance there about the frequency of checks for unused authentication credentials. So it's worth digging in on this one. There's quite a lengthy explanation for implementation guidance given within the standard, but there are some new mandatory activity which needs to take place around existing policy to make sure that old accounts basically are not resurrected, and simply put, that the frequency of checks for unused credentials take place, and that can change from jurisdiction to jurisdiction. So Wales, Ireland, Scotland, England and the EU may have different frequency of check requirements. So wherever you exist or wherever you trade, then it's certainly worth checking what local requirements are. So user access provisioning 922, at any given point in time now, an organization should be aware of who has access to systems which hold PII, and that stands to reason. It should be an enhancement of existing policies. Further to this, 27701 requires organizations to be able to understand what changes these users have made in terms of additions or deletions. So it's asking for traceability now. So wherever PII exists, whoever has access to that, people need to know at any given point in time. So it's more about ensuring that accounts are allocated and maintained correctly. So cryptography, there are some jurisdictions that require use of cryptographic mechanisms to protect particular kinds of PII. We're thinking health data here, and resident registration numbers, passport numbers, driver's license numbers, etc. There is some specific requirements, and 1011 or 6711 extension, it requires that these are taken into consideration. Secure disposal, as previously stated, any storage space which is reassigned must be subject to a review first to ensure that PII, which has previously been held within that space, is no longer accessible. And where PII has been deleted from a system, a complete erasure of PII can be impractical, and the associated risks which come with that must be addressed and included on an enhanced risk capture. Clear desk and clear screen. Hopefully not too many people are printing hard copy material, which includes PII, but there is a specified requirement now to keep that to a minimum. And it should just be a slight tweak of existing clear desk and clear screen policies to reflect the hard copy requirements. But it's well worth examining the wording of the implementation guide to see exactly what that looks like for you. So perhaps the largest part of the implementation guidance from Annex A controls over to the clause extensions in 27701 is concerned with information backup. It's a lengthy and important part of the controls outlined within the new standard. In addition to the extensions shown on screen, I can't list them all, the standard has a requirement for organizations to ensure that they're compliant with the frequency of backups. There is a specified requirement dependent upon the jurisdiction in which you operate, so it's worth checking where you are and what the local rules are. There is a mandatory frequency occurrence of backup to take place. So at the moment, the ISMS requires that you do frequently backup information if that's applicable, but now if you have information which is considered PII, then there are mandatory backup frequencies you must adhere to. Further to that, the organization should now have a log of PII restoration efforts. So if there is a procedure or there are instances where you restore PII, then a procedure should now be in place and a log of where that has occurred. At a minimum, the log of the PII restoration efforts need to contain the name of the person responsible for the restoration and a description of what PII has been restored. And again, that is skirting over a quite lengthy implementation guide within the standard, but there are some mandatory activities which must take place there, which are directed to organizations. Similarly, event logs are given quite a large implementation guidance, and the notes contained within are summarized just on screen there. But essentially it boils down to there should be now a process in place to be able to review event logs continuously. It does say automatically if that's what you can achieve. However, if it cannot be achieved automatically, then it should be frequency dictated, i.e. so there can be a traceable history of when event logs were monitored. So yeah, 1321, information transfer, not much more to add to what you can see on the screen. Procedures for ensuring the rules are established. NDA and confidentiality in agreement. In addition to agreements you may have in place for your ISMS, an extension is required for 27701. Any individual operating under the control of an organization who may have access to PII should be subject to confidentiality obligations. And this agreement can be part of a contract, or as I've recently done, sign an NDA, which has been raised specifically for the agreement and the information I'm going to be looking at. 1412, securing application services on public networks. Sometimes sending an email over the internet is inescapable. It has to be done. On such occasions, 1412 extension requires that cryptography is considered. Clearly, when you're sending an email, some PII is transmitted in the clear, for example, your email address and perhaps name, depending upon your email address. But applicable controls to maintain confidentiality of other PII should be taken. So protect what you can, essentially, is what that says. There's more development operations guidance, extensions, those are on screen. The standard now asks for full consideration to be given to where PII is collected and processes, along with what mechanisms are going to be implemented to ensure that no inadvertent collection takes place. For example, you're not going to, by proxy, take information that you haven't asked to take. Test data. So there is a specific guidance on test data. PII should not be used for testing purposes. False or synthetic PII should be generated and used for test data. Where the use of PII for testing purposes cannot be avoided, technical measures equivalent to those used in the production environment should be implemented to minimize the risks. Where such equivalent measures are not feasible, a risk assessment should be undertaken and used to inform the selection of appropriate controls to mitigate the risk. So essentially what that's saying is do not use PII for testing. Synthetic PII should be used, but where it's not able to be used, there is a specified process to follow now. It cannot be freehand. For reasons of time, there are some that I'm skipping over, but likewise, like I said, you will have the opportunity to ask questions or email me directly, and receive the slide deck on conclusion of this webinar. So the final slide on mapping across from Annex A to Clause 6 in the new standard. Responsibilities and procedures associated with incident management policy need to be enhanced now to include PII specific incidents. And this includes identification of a suitable party to notify relevant authorities when PII breach has been identified. So for organisations in the UK, if you're listening to me from the UK, the ICO provides a really good guidance on response time requirements for UK businesses and includes mandatory response and notification periods on identification of breach. And again, for brevity, I haven't included this in this slide deck, but the ICO website is well worth a visit if you haven't already. In terms of responding to incidents, any incident that involves PII should trigger a review by the organisation as part of its incident management process to determine if a breach involving PII that requires a response has taken place. So you have to evidence now that you've responded to PII breach. Importantly, when a breach has been identified, the response procedures now need to include notifications to authorities and to principals where appropriate. So examples, fairly well documented examples in recent times include the dissemination of the New Year's Honours List, which included the addresses of those award recipients, which was quickly recovered. However, notification of that breach was given to the right authority and the people affected were notified of the breach. And this is what it's saying now, that kind of example. As with the control requirements from 27001, an organisation is required to identify potential legal sanctions above the legal considerations now. So the legal sanctions which are related to the processing of PII. Again, for the UK-based organisations tuning in or listening to this further down the line, please look to the ICO as the local supervisory authority. Protection of records require a review of current and historical policies and procedures that can be required. For example, in the case of customer disputes and resolution of those disputes and where investigations were conducted by a supervisory authority. So you need to protect those records now. The organisation should retain copies of its policies, even those which have expired, and associated procedures for a period which is specified in its retention schedule. And this boils down to the PII controllers, which we're going to go on to next. It's one of their requirements. So an independent review of information security, and this can be the provision of evidence to customers prior to entering into a contract, that independent evidence that information security is fully implemented and operated. A relevant independent audit as selected by the organisation should normally be acceptable to fulfil this need. And then finally, the technical compliance review, as it's stated on the screen, ensure that only permitted processing of PII is taking place and/or penetration and vulnerability testing has taken place to identify where things aren't working as intended. And this should just be a simple enhancement of existing policy. Fairly dry, I appreciate that, but that's it in terms of mapping across from Annex A controls from 27001 with their required 27701 extensions. Although you may have heard the definitions and the names mentioned, for reasons of brevity, I've not gone into full detail over the roles of PII controllers and processes within an organisation. It is a requirement within the clause area of the new standard, but here is a very quick overview of the role of each. As previously stated, you must determine where they are a controller and/or a processor and ensure the implementation guidance given in the standard is followed, which addresses the requirements for each role. But in summary, the PII controller collects the information and determines the purposes for which it is processed. And then the processors process that personal information on behalf and only according to the direct instruction of the controller. So the next in the series of webinars, we'll look at these roles in more detail and kind of bring out the requirements, which we're going to look at now, of the production of the statement of applicability to go with each. So as alluded to, there is a requirement to extend existing SOA or create an additional SOA for both controllers and processes using the new controls which are listed within the standard. A review of each table within 27701, Annexes A and B respectively, will provide you with the required headings and break down what you see on screen even further. The inclusion or exclusion is the decision of the organisation based on the findings of their context review and how they control, either control or process PII. Each organisation is going to be different, and in some circumstances, and there could be both a controller and processor as the same person, same entity. On screen is a approximate breakout of the standard. In essence, it's the SOA for PII controllers. It should contain 31 entries with inclusions and exclusions justified accordingly. Similarly, PII processors should have their own SOA or delineated control considerations within existing SOAs, which you have for your existing ISMS. And those are broken down on screen. In essence, the SOA for PII processors should contain 18 entries with inclusions and exclusions justified. So that's it for this 27701 first look. We've examined the standard, the origins, why it's required, the benefits, and the pitfalls, followed by a short handrail through the initial implementation and how the requirements for the standard relate to your existing ISMS. Please do keep in touch. Keep an eye out for further 27701 webinar information, which we will disseminate once we've nailed down the dates. If you have any questions relating to that or to 27001, I'll be happy to answer those now. For those who've left, my email is on screen, and hopefully you'll reach out to me in the future. That concludes this webinar. As discussed, be happy to answer questions about this 27001 risk or other pertinent topics. If you have to leave us, then thank you for joining us. Please do feel free to drop me a line with any questions you may have, and I'll respond as soon as I am able. Okay, so I'm going to look at some of the questions now, if I can answer, get into that part. Well, good. Excuse me, having a few. Okay, the questions box is wrapped up for me. Sorry, bear with me a moment while I fix this. So yeah, apologies once again. Apologies to those who had some technical issues at the beginning. I hope I hope that when you receive the presentation further down the line, you sort of catch up on any bits you may have missed. But certainly appreciate you joining us and persevering if you managed to work your way through it with us. So one question from Neil: is 27701 intended to meet the requirements of a certification mechanism under Articles 42 and 42 of the GDPR? The answer is yes. GDPR is specifically mapped. So I think it's the final annex within the 27701 standard. There is a GDPR mapping tool, so it outlines the requirements of GDPR and then takes you to the part of the standard which specifically addresses various parts and clauses. If you haven't got a copy of the standard, I'd highly recommend it. It's not easy reading at first, but after a couple of reviews, you can see how it directly maps across to legislation. So Lee, forgive me, I've got your name wrong there, but I think it's Lee, is asking, I'm wondering if there are any particular competencies a person would need to develop, implement and audit a 27001 or 27701 system. So yes, if you are conducting a internal audit for any ISO system, then ideally you would be competent to lead author or auditor or lead implementer level for whichever standard you are looking at. 27701 is different in that it does not map directly across to a standard. It addresses legislation. So any kind of auditor with an awareness or knowledge of GDPR, data privacy, etc., is at the moment considered a suitable entity to conduct an internal audit for that. You can integrate with other standards. However, you must have a 27001 standard in place to implement the privacy information management system, because as we've shown in the presentation, some of the requirements of the new standard are directly mapped across from Annex A controls within 27001. So the generic clause areas of those standards mentioned, Lee, I think 14, 9 and 45 I can see there, those would help, but you have to have 27 in place before you can have a look at 27701. So Vidya, and again, apologize if I've got your name wrong there, Vidya, but you're asking about small businesses. For small businesses, I would refer you to our consultant register. Simply, if you're trying to go it alone, there is a lot of language which can get bogged down in. If you're trying to start from a position of no management system to achieving 27 and 27701, then I would certainly recommend that you speak to one of our consultants on the NQA consultant register, who will help you guide you through both of those processes. It is worthwhile doing, simply put, that if you can prove to potential customers that you have addressed information security and data privacy and have been certified as doing as such, then the benefits far outweigh the initial headaches of trying to get your head around what it means for you and how it could apply to your business. Certainly a worthwhile endeavor. Okay, Lee. Okay, and the rest of the questions there. Thank you, Lee. Pleased I got your name right, and similarly, Vidya, thank you. I'm glad I got your name right. It's not always good on a Friday after a long night, but good. The only other questions I can see on the screen there relating to some of the technical issues we had at the outset. Yes, we will certainly send you a recording of this presentation along with my email address. So if you have any questions which aren't apparent now but are apparent once you've had another chance to look at what we've presented today, then feel free. It doesn't matter if it's a day from now, a week from now. Hopefully 6 months from now, I'll have a little bit more because I'll have some auditing experience with this, be able to show you some of the common pitfalls that I've seen on the implementation. But unless there are specific questions addressed to what we have just covered today, then I will close this presentation in 10 seconds. Thank you very much for your time. Thank you for joining us, and we'll speak to you soon. Have a good day.